Structurally, precedent theory can have some nuances. We understand that prior court decisions about similar disputes are to be repeated. Now in Canada we've got a federal state. So we've got a federal government responsible by the Constitution for making laws in certain areas or for certain subjects, and we've got the provinces and territories able to make rules about other subjects. That's by the Constitution. We also have a diversity of courts. Supreme Court of Canada, of course, is the highest court in the land, but we've got a Queen's Bench in Manitoba, and we've got a Court of Appeal in Manitoba. We've got a different Queen's Bench in Saskatchewan and a different Court of Appeal in Saskatchewan. Now, the rules of precedent generally work like this. Decisions are binding on lower courts within the same jurisdiction. Supreme Court of Canada is in all jurisdictions. So a Supreme Court of Canada decision would be binding on the Court of Appeal of Manitoba and the Queen's Bench of Manitoba, and on the Court of Appeal of Saskatchewan and the Queen's Bench of Saskatchewan. A decision by the Court of Appeal of Manitoba is binding on lower courts within the jurisdiction. So it would be binding on the Queen's Bench of Manitoba, but it would not be binding on the Queen's Bench of Saskatchewan. Even though that's a lower court, it's in a different jurisdiction. And it would not be binding on the Saskatchewan Court of Appeal. Normally, a decision of the Court of Appeal of Manitoba would be binding on itself in subsequent cases. So we see precedent working downwards. It doesn't work upwards. A decision by the Manitoba Queen's Bench would not be binding on the Manitoba Court of Appeal, and it would not be binding on the Supreme Court of Canada. Also, it would not be binding on the Queen's Bench in Saskatchewan, which is in another jurisdiction, or the Court of Appeal in Saskatchewan. Where this can lead to difficulties is when someone asks the question, well, what's the rule of law in Canada about X? Well, we might have different rules from the Queen's Bench in BC than we'd have from the Queen's Bench in Manitoba. Because the Constitution distributes the rule-making power, and because the courts are binding within their jurisdiction downward, but not across jurisdictions, we can have a different rule on, say, dog bite, if it's not legislated, in BC than we may have in Manitoba. So, it is difficult to get the answer, what is the rule of law in Canada on X? Sometimes, because you might have different decisions from different courts in different areas, and each from different times. And because they're not binding on each other, you could have the Queen's Bench of Manitoba saying, we're going to make a decision, notwithstanding that we understand that Saskatchewan has made a decision that went a different way. This is Manitoba, and we have authority to make the decision a different way here. So you could have the same fact situation with different outcomes in those two provinces. Simply because they're different courts, they're applying the values in those areas, and they can be different. And that wouldn't violate precedent theory. So it's tough to get the answer, what's the rule of law in Canada? Because there may be, the answer may be, well, it depends where in Canada you are. Because there's different courts in different places. Now, of course, if the Supreme Court of Canada made a decision on dog biting, it would be binding right across the country, because it's the higher court.